Russian
I think somebody is senior. I want to go watch it.
or Iran. They've just picked the son of the supreme leader to be the next supreme leader.
That's great. Did he pick up golf from you?
2,500 years.
I have to kill him for the supreme leader.
Playing golf.
No, the second guy.
All right.
He was the only one.
Assuming you can hear me?
I picked up golf.
All right. Thanks, you all, for coming. Good evening, and welcome to tonight's installment of the Daniel Webster Debate Series. This series is named in honor of Daniel Webster, one of our nation's greatest orators, public servants, and advocates. Founded just last year, the series has quickly become the heartbeat of our chapter and a cornerstone of serious legal conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage the most pressing constitutional questions of our time. Tonight's resolution asks, does originalism truly constrain judges? This question lies at the core of the Federalist Society's beliefs. That it is emphatically the province of the judiciary to say what the law is and not what it should be. One of originalism's central claims is that interpreting the Constitution according to its original meaning constrains judicial discretion by anchoring constitutional interpretation in a fixed historical meaning rather than involving provinces of judges. Yet whether originalism in practice consistently delivers on that promise remains a subject of vigorous debate. Tonight's discussion will give us the opportunity to explore that question in depth. And it's especially fitting that we do so today on what would have been, and what is, Justice Antonin Scalia's 90th birthday. A man who did more than perhaps anyone else to bring originalism into the mainstream. So to examine this rich and contested issue, it is my honor to host two outstanding scholars and to welcome Judge Amul R as tonight's moderator. Without further ado, please join me in welcoming our Director of Debates, Louis Pham, who will formally introduce our three distinguished panelists. Thank you so much.
Thank you, everyone, for coming tonight. Judge Emil Thapar of the U.S. Court of Appeals for the Sixth Circuit is the first South Asian Article III judge. Prior to his confirmation on the Sixth Circuit, he served as judge on the U.S. District Court for the Eastern District of Kentucky and as the U.S. Attorney for the Eastern District of Kentucky. He received his undergraduate degree from Boston College and his law degree from the University of California, Berkeley. Neily is a senior vice president for legal studies at the Cato Institute. His areas of interest include constitutional law, overcriminalization, coercive plea bargaining, police accountability, and gun rights. He received his Bachelor of Arts from the University of Texas at Austin and received a law degree from the University of Texas. Professor Mikhail is the Carroll Professor of Jurisprudence at Georgetown University Law Center, where he has taught since 2004. He teaches and writes on a variety of topics, including constitutional law, moral psychology, moral and legal theory, cognitive science, legal history, criminal law, torts, international law, and human rights. He received his BA from Amherst College, a PhD in philosophy from Cornell, and his JD from Stanford Law School. And with that, I welcome tonight's debate. Thank you.
Well, thank you all for having us. It's an honor to be here on Justice Scalia's 90th birthday with two of my good friends who I've known a while. I've known John actually since, 1983, maybe? So long before most of you were born, probably closer to when your parents were born, so that talks about us, not you, but it's great to be here to talk about one of my favorite topics, originalism, and I get to serve as the moderator, which is a ton of fun because I get to listen to two brilliant people and then just ask them questions. But I don't love the title, and I'm going to tell you why, because I don't think originalism is either a doctrine of restraint or a doctrine of activism. Rather, I think what originalism is a philosophy that judges employ to figure out results. And so what I mean by that, Keith Whittington has this great article about old originalism and new originalism. And old originalism, he talks about being a restraint doctrine in part. I don't want to put words in his mouth, but he essentially says that, and he says it's in reaction to the Warren Court's activism. And what Professor Whittington says is that as a result of the Warren Court's activism, people like Scalia and Bork wanted to bring back originalism, the originalism that Brutus envisioned and that Hamilton promised in essence. They wanted to bring it back to the courts. And they brought it back not in a form of Thaparian restraint, but still a doctrine that would restrain judges from going outside their lane and writing rights into the Constitution. So in that sense, yes, it is a doctrine of restraint. But it's also not a doctrine of restraint when people come to the court and ask that rights that actually exist in the Constitution be vindicated. Then it is emphatically the judge's job to say what the law is, not to restrain and leave it to other branches of government. Unless you don't believe in Marbury, which is a different topic for a different time, I think judges' obligation is to say what the law is. And as long as it's their obligation to say what the law is, then when there's a case or controversy in front of them, they must. Now let me give you just a quick example of where the court got off track, in my opinion, and maybe still is a little bit off track, and that is with eminent domain. I'm just going to pick one example. I can go through many. But in eminent domain, there was a case in the 1950s called Berman v. Parker out of Washington, D.C., where the Supreme Court actually changed the language of the Constitution. I'm not going to get into details now. We can maybe in the Q&A or maybe with your all's Q&A. But they changed it from the government could take your property for public use with just compensation to public purpose. And that was a much more deferential doctrine, right? Because if the legislature doesn't have to show they're actually going to use the property for public use, but can just come up with a purpose, as Justice Scalia pointed out, a purpose can be higher tax dollars, where you take from the poor and give to the rich because they pay more money, right? Pay more tax dollars. That's a public purpose, capturing taxes. So there the court rewrote the Constitution to employ a doctrine of restraint, when in fact they should not have done that. If you're an originalist, you believe they should have interpreted the terms. What did public use mean at the founding? It meant things like taking a sliver of your land to extend the roads, taking a portion of your land to put in a sidewalk. In the most extreme cases, taking all your land to put in a subway system or something of that sort, or a train, right? But they were for the public use. And once they changed to public purpose, that is a doctrine of deference, but it's inconsistent with the Constitution, and so an originalist should not follow that path. Okay, so that's my quick thesis. That's what I steal from Keith Whittington, who's a lot smarter than me, a professor, and talk about how originalism should be. He's got this great article about new originalism. I think it's from 2002 or something, that if you get a chance, it's an easy read, and it'll say it much better than me. Okay, Clark, your turn.
Thank you. Well, as a former litigator, I'm going to start this way and say I'm in complete agreement with Judge Thapar, which is a really good way to start an oral argument if you can. We didn't coordinate at all, but actually what he just did is about 2 or 3 minutes, he just actually distilled this entire outline. So I don't know what's left for me to I'll figure out something to say. But I think there's still some interesting material to be mined here, I hope. I would like to start with an anecdote. I don't think you know this, but I was on the Kelo trial team. So Kelo versus City of New London was a 2005 case in which the Supreme Court further abused the doctrine of eminent domain.
Were you at the Institute for Justice?
I was at IJ for 17 years. So I got to actually cross-examine an expert during the trial, and then I didn't argue the case. That was my colleague, Scott Bullock, but can you hear me okay? Yeah, good, okay. But the anecdote I wanted to share was what happened in the Supreme Court. Our probably most difficult precedent in the Kelo case was a 1984 case called Hawaii Housing Authority v. Midkiff. It's an opinion written by Justice O'Connor that really kind of said the sky's the limit. I think it applied rational basis review to eminent domain cases, and once that happens, it's all over. And so we felt that she would probably be could well be the swing justice, and. I think this is one of the only times I've seen this in the Supreme Court, or at least seen it so close that I knew exactly what happened. She was trying to explore the implications of our opposing counsel's theory of eminent domain. And she said, okay, so just to be clear, and for those who don't remember, Kelo involved a taking of private property in a place called New London, Connecticut, to essentially transfer it to a property developer to take a bunch of lower middle class homes and turn them into upper middle class homes, and to build a bunch of office space and hotel space. And the theory of public use there was that it would increase the tax base and perhaps provide some extra jobs. And so,
although you're leaving out the most important part.
I'm sure I am.
They did it at Pfizer's request.
Well, that's right. Okay, yeah. We actually got some discovery where there was a document that listed Pfizer's requirements. We felt that was rather more relevant than, unfortunately, some of the judges did. Anyway, so Justice O'Connor asked Wes Horton, who was our opposing counsel representing the City of New London, just to understand what your theory of eminent domain is, if the government wanted to take a Motel 6 and replace it with a Ritz-Carlton, just because that's a more expensive hotel that would generate more taxes, would that be a permissible public use in your view? And he said, yes, Justice O'Connor, it would. And I've never seen, she'd lean back like this and she was just gone. Here's check out. You knew that he lost her vote in that minute. Lucky for him, he picked up Justice Kennedy, and so Thilo came out the wrong way from the perspective of us on the plaintiff's side. But anyway, so thank you for giving me the opportunity to tell that anecdote. I want to put my conclusion up front, which is that originalism sometimes constrains judges, but I think not as much as it could or should. And let me give you two kind of whimsical examples where originalism. And let's be clear, like there's not like originalism. There's not like you know a giraffe when you see it. Well, hopefully you would. At least you know it's not a warthog. But originalism comes like in lots of different sort of flavors and guises, and so that could be a challenge. I don't know if it will be. If I were a law professor, it definitely would be, because we all have our sort of shades of distinction. But the examples I wanted to give where you could see originalism doing some work, and in one example, it's going to essentially help confirm a rather obvious result, and in the other example, it's going to produce a completely ridiculous result, an absurd result, but I think would be compelled by a serious commitment to originalism. So the one that helps produce the right result would be, what if we colonize the other planets, right? And we've got human beings living on Venus, and somebody is running for president from Venus, and they are 35 Venus years old. Does anybody know how old that person is in Earth years? Just out of curiosity, 21.5 Earth years. That's how many years have gone by on Earth when 35 years have gone by on Venus. And they are absolutely certain that being 35 Venusian years old, they are eligible to be president. Originalism could come into play there and it might seem so obvious that it's not even originalism, but how about just asking, well, like, where was the Constitution enacted? Planet Earth. Okay, that's helpful, right? That would be a form of originalism at work, and I think would basically answer the question. Now let's go to the more absurd one. Imagine there's a constitutional provision that was written in the late 18th century that said that people may take any number of fish from, I don't know, Long Island Sound, something like that. Well, guess what that would mean today? That would actually mean, if you're going to be a serious originalist, let me ask you a question. Would that protect your right to take whales from Long Island Sound? It certainly would. Because guess what? That's what fish meant back then. Whales were called fish. They were referred to as fish. No question about it, none. That result, I think, would seem absurd to us today, but if you're seriously committed to originalism and you go back and you understand what the original public understanding or meaning of fish was in the late 18th century, it was definitely including whales. And so that's, if you're going to be a serious originalist, that constitutional right protects people's right to not just take what we consider to be fish, but also cetaceans. So that would be an example, I think, of where originalism could constrain a judge who might be inclined to say, let's leave those poor endangered whales alone, but I wish I could, but I can't, because I'm going to be a serious originalist and talk about or try to figure out what the meaning of this word was, what it was understood to mean at the time of ratification. What I want to talk about, or spend the rest of my time sort of focusing on, is that I think there are actually kind of different levels of originalism that turn out to be really important. And I think Judge Thapar kind of alluded to this to some extent, and I'll see if I can sort of tease it out as a former constitutional litigator, because I've run into it a bunch. I played with the idea of calling it forest for the trees originalism, and then I thought, maybe that sounds kind of pejorative, and then I further thought, well, I'm not in court, so I get to call it what I want, and I'm going to call it forest for the trees originalism, where essentially you're getting so laser focused on one aspect of a question that you are perhaps not sufficiently focused on equally or more important aspect. And I'll just give you an example. Imagine you really drill down on the original understanding of the word unreasonable in the Fourth Amendment in a search and seizure case, and you get a pretty good understanding of it. Like really, I don't know, maybe I don't know if, what is it, corpus? Is it corpus linguistics, whatever it is?
Corpus linguistics.
Supports your interpretation, and I don't know, maybe even Joseph's story, whatever. But then you apply that, let's say, correct understanding or very accurate understanding of the word unreasonable in a framework where you are also applying, anybody familiar with, this has been getting a lot of press lately, the presumption of regularity. Anybody heard of this? The presumption of regularity is a judicial mindset. I wouldn't call it a doctrine quite, but a sort of a judicial mindset or attitude that, at least in certain settings, government litigants are entitled to a higher level of not deference exactly, but belief, regard from judges. That essentially, even if the government maybe doesn't have evidence to support a point that it's making, or it's making a representation about its future intentions that may be contestable and you can't really prove one way or the other what you're going to do in the future, that there is this thing called a presumption of regularity, which is really just a fancy way of saying they get a boost compared to a non-governmental litigant. And I saw the eye roll. Thank you, sir. That's going to stick in my mind because I feel the same way. As somebody who challenged, spent 15 years of my life challenging the government, well, I mean, why do they get a presumption of regularity? I don't get it. I mean, is there some empirical evidence that government litigants are in fact more honest or more reliable when they make representations for which they don't have any evidence in court? Possibly. I'm not aware of any. More importantly, I'm not aware that anybody's even looked for any. It's just a thing that arises. And the reason I'm harping on this, I guess it's twofold. Because I hate the presumption of regularity. Like, I don't know, I can't make a funny reference that'll connect with you, but like a Californian hates gluten or something like that. Thank you. And so that's one point. But more importantly, what do you think the founding generation would have thought of the doctrine of originalism? Did they seem like super confident in the probity of government officials? Does that seem like really consistent with the animating principles of the Constitution? You may be familiar with all those structures, vertical, horizontal, and other, that were put in there to constrain government. This doesn't strike me as a generation that had an excessive degree of confidence in the goodwill or the reliability of government or its inclination to follow the rules. And so what you could end up doing as a judge is having an extremely reliable understanding of originalism at the level of a particular term that's relevant to the outcome of the case, in this case, unreasonable within the Fourth Amendment. But then you do the rest of your analysis through an extraordinarily unoriginalist framework, like the presumption of regularity, which, depending on how much work it's doing in that case, might produce a result that is profoundly unoriginal. Does that sort of make sense? And I probably just got a couple more minutes, so I won't go through my entire list, but I may work some more in later. The last illustration I would give you is the fascinating, I don't even know whether to call it a dialogue or a monologue. What do you think Justice Gorsuch's concurrence was in the learning resources case, the IEPA case? I'm going to just call that a monologue. Okay. And so... And
They responded.
Well, okay, so whatever that is, a multi-log. But for those who haven't read it, I strongly commend it to your attention. It's a fantastic read as far as I'm concerned, but he engages with all of the other opinions in that case. And he, I think, does a fascinating job of critiquing Justice Thomas's dissent. And I can't do it justice, obviously, because I'm not Justice Gorsuch, but I'll just point out that if you read this part of his opinion, again, which I strongly, is a concurring opinion, strongly encourage you to do, he does a really nice job of showing how arguably Justice Thomas kind of lost the forest for the trees. He went back and he looked at all these ancient sources, and before 1688, the power to tax imports was a monarchical power, and so the king definitely had that power, and there's all this evidence to support that. But sort of failed to then say, well, what was the Boston Tea Party about exactly? Oh, that was about import duties. Did they seem a little exercised about that when the king just shoving that down their throat? They did, didn't they? Right? And by the way, this is not me being snarky. This is, well, I'm sort of projecting Gorsuch snark, I guess. And he wasn't being snarky, but I mean, he's not pulling his punches either. And so that might be an example where you might have a really good handle on a word like tariff or impost or duty or whatever the relevant terminology might be. But if your kind of framework is insufficiently originalist, then you can come out with a result that every member of the founding generation would look at that and say, are you bonkers? Like that's as nuts as, I don't know, letting somebody run for president who's 35 years old on Venus but only 21 on Earth. That's a preposterous result. So I guess I'll close by saying that I think originalism in some quarters gets kind of bad press. And I think that's a bit of a straw man. People essentially say, well, look, if originalism can't give me a clear and indisputable answer to all questions that arise under the Constitution, it must not be any good. I reject that. That's not fair. But again, what I would say is that it's not a kind of a monolithic concept. And you have to have, I think, you have to spread your kind of perception and remember that to get cases, to get the right answer in cases, you have to be careful not to unduly focus on very specific applications of originalism when there may be other arguably more relevant applications of originalism waiting in the wings that you're not even looking at. Does that make sense? So I think there's a lot to commend it. I think it can provide a constraining function, but I don't think it does provide a constraining function as often as it ought to.
John?
Okay, thank you very much. I want to begin by thanking the organizers, Dennis and others, for inviting me. It's really a pleasure to be here. It's a pleasure to get to meet Clark Neily and be on this panel with him because I've admired his work at Cato for quite a while, especially in the area of qualified immunity and the Fourth Amendment. It's very important work, I believe. And it's a special thrill to be on this panel with Judge Thapar because, as he mentioned, we were boyhood friends. We both attended a small school in Northwest Ohio together back in, starting the 4th or 5th or 6th grade for several years. Sometime back I sent...
Maybe it was late 70s even.
I think it was late 70s, actually. I think you shortchanged just a few years.
I didn't want them to know that we...
how old exactly we are. So I've had the chance to watch his career unfold with, great admiration. And I'm glad one of us ended up being a judge. I'll put it that way.
Not you. You're glad not you.
No, it is a real pleasure to be here, and I'm grateful. So I'll just throw out a few framework kind of thoughts on the question. It's not a topic that I had given all that much specific thought to. Of course, I'm very familiar with the originalist literature. I actually, in preparation for this panel, read a short piece by Will Bode called Originalism as a Constraint on Judges from the 2017 Chicago Law Review, and it was helpful to kind of put my mind in the right place. He draws some distinctions that I'll return to in a moment. But my own distinctions that I would bring to this question, we're not asking in our topic for tonight, should originalism constrain judges? That's not the question we were asked to discuss. Although that is the question that I think most originalists, when they write about the so-called constraint principle, are in fact talking about. So my former colleague Larry Solom, who's now at the University of Virginia, maybe clearly one of the leading originalist theorists, talks about the two principles that almost all originalists agree upon. One is the fixation thesis, the idea that the meaning of the words of the Constitution is fixed at the moment they're adopted. And the second is the constraint principle. And he formulates the constraint principle as an ought statement or a should statement. His version of the constraint principle is that originalism ought to constrain judges and other legal actors. So that's the sort of normative claim about constraint. But that's not exactly what we were asked to discuss today. So I just want to kind of flag that and then set it to one side. Another question you might ask, and this has already come up, is can originalism constrain judges? Is it capable of doing that? If you buy into the principle that ought implies can, then people like Professor Solom are committed to that view, and originalists who sign on to the idea that originalism should or ought to constrain judges must necessarily believe that originalism can constrain judges. Again, though, that wasn't the topic that we were asked to discuss, so I just want to flag it and put it to one side for a moment. We were asked to address the question, does originalism constrain judges? And on that question, I'm not so sure. I agree with Clark, the sometimes answer I'm very comfortable with. I think sometimes it does, sometimes it doesn't. Professor Bode draws an interesting distinction, I think it's helpful, between two ways that originalism might in fact constrain judges. And he talks about an external constraint and an internal constraint. By an external constraint, he means the way that the sort of practice of originalism or the methods of originalism that people other than judges can use as a metric to evaluate the work that judges do, whether that can happen, whether that does happen. And I think he says that it does happen, right? So the rest of us can look to originalism and apply it as a kind of measure of whether judges are being constrained by originalism. So in that sense, there's a kind of constraint insofar as the judges care about what the rest of us think. But he's more interested, Professor Bode, that is, in the internal constraint of originalism. And for that, he's really talking about how originalism affects the decision-making of the judge himself or herself, right? And what he points out there is that really is just a question of the kind of conscientiousness or good faith commitment of the individual judge to originalism, right? I mean, that when it really comes down to it, is the judge ready to be constrained by originalism? Does it? Well, it's going to depend judge by judge, right? It's going to depend court by court. Structurally in our system, and this is actually an interesting a question that I have interest in that maybe Judge Thapar would want to opine on, inferior federal judges are bound by other things than originalism, like precedent. In the hierarchy of the judicial system, it's not always going to be an opportunity for them to write an originalist opinion if, for example, there are non-originalist precedents that are more or less directly on point. They may write a concurrence, an originalist concurrence, say, look, I'm bound by precedent, but here's what I really think, and send a signal up to the Supreme Court about whether maybe they should be thinking differently about their own precedents. That's, one possibility. But there is a kind of straightforward analysis or answer, I guess, to the question, or reframing of the question. If we distinguish inferior federal judges, and state court judges for that matter, from the justices of the Supreme Court, now we're in a different area altogether again. So does originalism constrain justices of the Supreme Court? Maybe now we're on to the question in its even sharper form. And there I think Bode's distinction is helpful, the external versus the internal. I'm not so sure, frankly. I can't read the mind of the justices. I know many of them profess to be originalists. And I know many of them sometimes write originalist opinions, but I'm also pretty aware that many of them sometimes sign on to non-originalist opinions, or say nothing about what I think of as, and many would think of as, a stronger originalist argument for a certain conclusion. In the Trump against Anderson case, the Colorado disqualification case, there was a lot of effort and time that went into making clear to the justices what the original materials had to say about Section 3 of the 14th Amendment. Didn't seem to have that much uptake, right? From any of the justices, including the professed originalist ones. Maybe, Justice Thomas maybe is more along those lines than others, but not even him. I could go down the list. I mean, there's just a lot of examples of whole bodies of doctrine in the First Amendment area, in the war powers area, in the removal cases, Trump against Slaughter. Again, a lot of attention recently being given by scholars to the originalist question. Was Myers rightly decided? Can we make originalist sense of Humphreys? What actually was going on in the decision of 1789? What's our best understanding of what the framers intended with respect to the removal power? But it all didn't seem to make that much difference in at least the way the oral argument unfolded. My prediction is there will be a few gestures in the direction. Maybe the phrase, the decision of 1789, will get mentioned once or twice. But it actually seems like the court is focused on different things, their own vision of the presidency and the modern administrative state and so on and so forth. So I'm kind of skeptical, to be honest, whether originalism constrains the justices all that much or very consistently. I'll end, though, on a more positive note. I think it constrains other actors in the system. And two that I'll mention are litigants, or litigators on behalf of litigants, and scholars. So I actually find when a new constitutional question comes my way, even though I don't identify as an originalist, I pretty much act like one, which is to say the very first thing I do is go to the original source materials. I want to know the drafting history. I want to know the pre-constitutional background. I want to know how the first Congress interpreted the provision. I want to know how the first administrations interpreted it. When I finally get to precedent, I'm usually evaluating the precedent in light of my then understanding of the originalist answer to the question. I honestly don't know any other way to go about digging into a constitutional topic of that sort. Yes, if there are clear, more recent precedents on point, then you maybe look to those. But when you get a newish type of a question, or one that isn't squarely controlled by existing precedent, just speaking for myself and many of the scholars who I hang out with, the group of people who I mostly kibitz with out at the Originalism Conference and other places, that's what we all do. And we do feel constrained by those materials. What it basically does is narrow the choice space, right? You can hone in on the potential ambiguities in the original evidence. You can understand what the clear answers are and what the unclear answers are, and so on and so forth. So I think the scholarly community, those who are engaged in the enterprise, are in fact somewhat constrained by originalism. And then, and maybe this is something Clark can speak to, and I'll end here, my impression is that litigators, when they are in fact arguing to the court, do feel somewhat constrained, right? It's notable, for example, in the birthright citizenship case, the case that's been on my mind lately, there are, 60 some amicus briefs in the that have been submitted, and the parties' briefs, except for the government's reply brief, those have been submitted. There's a lot of originalist argumentation in those briefs. And I imagine it's because those lawyers think we are constrained by originalism. We can't make overtly non-originalist arguments to this court and hope to get the same kind of attention or the same kind of persuasion that we will if we make originalist arguments. So there are a lot of actors in our system, sometimes lower federal judges when they have the opportunity, but maybe not that often. The scholarly community, the community of litigators. What I'm a little bit less clear on is whether the justices themselves are in fact all that bound by originalism as it plays out in practice. So let me stop there. Thanks.
2 minutes.
Yeah, thank you. So I thought I'd just quickly sort of tell another anecdote that will illustrate actually a point of very strong agreement between, I think, myself and John. I was one of the lawyers that brought the Heller gun case to the Supreme Court in 2008. I was actually a backup quarterback, so I had to be ready to present the argument. I didn't get to say anything. If you're wondering whether the backup quarterback hopes that the starting quarterback gets food poisoning, yeah, he does. But my co-counsel, Alan Grua, who did a great job arguing the Heller case, did something that was so impressive to me. So we were in the court when the decision came down. Of course, we were elated. We went outside, and you get to do that thing where you walk up to the big bank of cameras, and you get to gloat about your win. But as we're coming down the steps, I hear Alan over my shoulder. He's calling his local counsel. This is about 13 minutes after the decision was announced to file what became the McDonald versus City of Chicago case the same day that we won Heller's. For those who don't know, that was the follow-up case about whether the right to keep and bear arms is incorporated against the states through the 14th Amendment. So I worked with Alan on that case just kind of informally, and he did something that, John, I don't know if this is what you were suggesting or not, but he did something that surprised a lot of longtime Supreme Court advocates, which is that he led with a privileges or immunities clause argument instead of substantive due process. And he got a lot of flack for that, and we actually spoke on the night before on the phone about his decision to lead with privileges or immunities, and he asked me, should I stick with that? I'm like, yeah, you should stick with that. But I work for an organization that's trying to revive the privileges or immunities clause. Does anybody remember what happened to him?
You got one vote.
He got one vote as Justice Thomas, but he got absolutely assailed by a particular justice
90th birthday.
Whose 90th birthday would have been today.
That's right.
Justice Scalia was never shy about his absolute disdain for substantive due process and his strong belief in originalism. And I'm here to tell you, as somebody who worked with the privileges or immunities clause on at least a weekly basis and probably has written more articles about it than anybody in this room, doesn't mean I'm right, but I've studied the hell out of it. That was the originalist argument to make in the McDonald case, and it didn't go anywhere. And Justice Scalia ended up, he didn't write, he signed on to the, it was Justice Alito, right, who said, well, we're going to hold our nose and uphold this right under substantive due process. And here's that beautiful privileges or immunities argument just sitting there, articulated so beautifully by Justice Thomas in his concurrence, and it didn't even attract the vote of the court's number one originalist. So
I don't know that Alito had to hold his nose, because I think Glucksberg, he does believe in some level of stare decisis.
I think I was attributing the nose holding to Justice Scalia when he joined the opinion, but
Okay.
So thank you. That's
Although
all.
he said it's right, this is for academics, this proves John's point, although I've got a counter, but he said that's for academics.
Well, he said it a little more pointedly. He said, what are you bucking for a job in academia? Alan? Not anymore.
So that's a great example. I remember this as well. I think Justice Scalia called it the darling of the professoriate.
Yes.
Right? The privileges or immunities clause. But it's a great example.
And Justice Thomas.
And Justice Thomas, yeah.
He didn't say that, but
On the other hand, Justice Thomas, I think that's why and Justice Gorsuch to some extent, I think that's why they're two of the more interesting justices for academics who work in this space, is they are actually willing to go in this direction. I mean, this tariff case was fascinating. The series of opinions. I've actually worked on some of the issues that Justice Thomas was writing about. I know he's getting a lot of flack for this opinion, saying how crazy it is, but at least some of the, so he was drawing heavily from Professor Michael McConnell's recent book, The President Who Would Not Be King. And Professor McConnell, more than anybody ever, has dug into how Article 1 and Article 2 were actually drafted with respect to presidential powers. And the basic thesis is that
prerogative powers.
Well, that's it. The basic thesis is that the principal framers in the Committee of Detail, James Wilson and John Rutledge, allocated the prerogative powers to Congress and the President. And that, to some extent, undergirds what Justice Thomas is talking about, because the idea is many of the enumerated powers of Congress in Article 1, Section 8 were what the founding generation would have understood as either prerogative powers or basically executive powers. I mean, there's a little bit of more to say on that, but you can go to Blackstone, for example, and in Blackstone's chapter on executive powers, speaking of the British Crown, many of the powers that he discusses and analyzes are in Article 1, Section 8. They're things that we've come to believe now are legislative powers, and Justice Thomas is pointing out, well, maybe the fact that they're in Article 1, Section 8 doesn't end the matter. Justice Gorsuch was more like, no, it ends. It's far too late in the day for us to start deciding that some quintessentially legislative powers are actually executive powers and then draw conclusions from that. But so it's interesting stuff, but yeah, we're talking about one or two justices. I doubt very much that the Kavanaughs and Barretts and Robertses and so on of the court, the more pragmatic, rough middle of the court, is going to go for strong originalist arguments that might upend a lot of settled law. A last example I'll make in this regard, and then I'll shut up. I'm forgetting the name of the case, but Justice Thomas, with Justice Gorsuch joining him, recently came out with a new understanding of the ex post facto clause, or clauses, hearkening back to Calder versus Bull, and basically, in a concurring opinion, making the case that maybe we've been interpreting those clauses too narrowly because the original understanding was more capacious, and it would basically that the founding generation didn't have the same understanding of criminal offense as we now deploy when we say that the ex post facto clause is limited to retroactive criminal laws only. And it would provide a space, and I think Justice Gorsuch would love this, for finding a fair bit of what we think of as civil regulation could be subject to ex post facto analysis and held invalid. Now, that's again just two justices. Is the court prepared to, go strong in that direction? I very much doubt it.
So I'm going to ask one question, then I'm going to open it up. I have a lot of questions, but I guess my one question is, Justice Scalia, each of you talk about that originalism should constrain judges/courts more, and you kind of vary justices from this side, courts a little more from this side. I agree lower courts are in a different ballpark, so let's talk for a minute about the Supreme Court. And Justice Scalia famously talked about how originalism constrained him. And he used a couple of examples that I don't think anyone here would make the argument that Justice Scalia would be in favor of burning flags. And he pointed to the flag burning case. And he also pointed out how he didn't particularly like criminals. And yet, in cases like Michigan v. Bryant and other cases, he was maybe, I don't want to say the furthest left, because that's a bad terminology when it comes to criminal law, but maybe he was the most, let's just call it originalist for now, the most originalist on the court. And it seems in those two areas at the very least, Jones another example, where originalism constrained him. And in fact, in Jones, Justice Alito kind of made fun of him for the constraining principles of originalism and the way he was treating it. So how would you respond to that about whether originalism constrains justices? Either one.
I mean, yes, I think it can. I think that's, we're back to the point, is that it can, probably should, more than it does. I would add to that list Justice Scalia's wonderful dissent in Maryland v. King, which was the cheek swab case. The majority essentially, so this is the idea that they were taking warrantless cheek swabs to get people's DNA. And I think it was, Maryland, anybody who was arrested, they just did it automatically. And the majority said that's permissible, and Justice Scalia said, no, that's a search, and it was a pretty, it was an originalist opinion. And it, kind of warmed my heart also that he sort of mocked the rationale that the majority accepted, which is this is not to run it through a database and see if this guy did any other crimes. We're just making sure we got the guy we think we got. It's really John Smith who was born on such and such a date, which is ludicrous. No, they're running it through a database to see if he crimed anywhere else. But that's a more pragmatic approach. I think there were a couple of reasons why to get that case right. So, the bottom line is, we could say that Justice Scalia, I think, really essentially created or earned a well-deserved reputation for being so serious about originalism that he frequently either wrote or joined outcomes in criminal cases that he probably found personally uncongenial, and yet in the McDonald versus City of Chicago case, it not only wouldn't embrace the most originalist approach to the result that he favored, he mocked the litigant who presented the most originalist argument in that case.
I'll push back for a minute on that, although I'm not saying I agree or disagree, but I want to point out that Justice Scalia, you could think that the reason, and I'm not saying this 100% certainty, you could think the reason he's doing that is Justice Scalia was someone that wanted to restrain judges from finding rights. And so it seemed to me, was worried that he liked, like I said about Alito, the Glucksberg test is constraining if properly applied. It is a difficult test to meet. Washington v. Glucksberg substitute.
It's fatal if properly applied.
Okay. And so he living in that world, whereas privileges or immunities clause, he's worried that Justice Thomas wants to open the floodgates to rights through the privileges or immunities clause. And I'll give you an example of a case, which is the violent video games case, where Justice Thomas talks about the rights of parents to raise, for lack of a better way of saying it, to raise their children as they see fit, and the support of the state. And Justice Scalia says, no, free speech rights, this is all nonsense. There's no right of parents in the Constitution. And so I think Justice Scalia is still from the constraint, using terminology, old originalist does want originalism to be a doctrine of constraint. And I think Justice Thomas sees it not as much as a doctrine of constraint, although there are times it's constraining. Alene is an example of a Thomas case where he ruled that mandatory minimums have to be proven to a jury. Again, a pro-criminal defendant case that you wouldn't associate Clarence Thomas with pro-criminal defendant's case, where most of the conservatives, in fact, I think all four, dissented, and he was with what would be, quote-unquote, the four liberals. So I think, depending on how you define the court, how you define the justices, you gave a fair summary of the newer court, but you can do it however you want. My point being is, there are times where it clearly constrains the justices, and I think Scalia, because it's his 90th birthday, we should talk about him. John, why am I wrong? Why aren't all these cases examples of constraints on Scalia that he's using?
Yeah, so I don't disagree. I think the examples you just mentioned are good ones, and the one that comes to my mind most frequently is the flag burning case. Those cases, and Justice Scalia clearly, had no sympathy for flag burning, and everyone kind of understood that. And that was a nice example. That is a nice example of a clear moment where he is both signaling and doing a jurisprudence where preferences and outcome are coming apart, right? And that's sort of the point. What is originalism purportedly constraining judges to do and to not do? Well, the not do is to just simply go with their preferences, right? In a post-legal realist world, we're all so accustomed to thinking about courts this way, whether, for good or for ill. It's just about the politics and the policy all the way down. And Justice Scalia wanted to make clear, and did make clear, I think, that there was a check on that. And originalism is a check on that. And I don't disagree with that. So I will say that a judge in that position can be opportunistic about the moments where they play that card, because there are always going to be these other cases where they don't, right? My kind of take on the extent of originalism that's actually deployed by the justices is that it ends up always being a kind of cafeteria originalism, right? I was raised Catholic, so cafeteria Catholicism is kind of like a thing in my mind. That means you pick and choose, right? You're not taking the whole kit and caboodle. You get to pick which parts of the doctrine you like. And the truth is, I think, that many originalists, even the staunchest originalists on the court, even Justice Scalia, necessarily, and maybe for good reasons, right? But they end up being cafeteria originalists. The good interpretation of that is inevitably there are other values at stake. There are other modalities at stake, right? So we can think of a strong version of originalism standing in stark opposition to the multiple modalities approach to constitutional law, or the pluralistic approach where you have all of the, however many you want, text, history, structure, precedent, consequences, prudence, ethos, and so on. And originalism tells you, don't do any of that, just do originalism, or just do the parts of that that are consistent with originalism. But another way to think about the dichotomy of the opposition between these ways of doing jurisprudence is that originalism can be a weaker constraint than a sharp rejection of the modalities when they come into conflict. It just weights originalism stronger, right? So there's still always going to be room for, here's my best originalist understanding of the case, but I'm willing to look to consequences, and I'm willing to look to precedent, and and I think all the justices do that, whether or not they are, upfront about that or not. They just do, in certain moments, look to functionalist reasoning, they look to consequences, they look to precedent, they look to, kind of what the effect of their decision is going to be, in a very understandable way. I'm not sure I would want the justices to do anything else than that. Otherwise, you'd have a zealous ideologue who's like, I got the one method and I'm going to, let the heavens fall. I'm just going to do originalism each and every time. So I think it's a good thing that they're cafeteria originalists, but I do think that's what they are.
All right, questions from the audience? Yes?
So, as a Catholic, Mr. Mikhail, I understand.
I didn't mean to bring my religion
No,
into
I
the matter.
understand.
Maybe I should have.
I think Catholicism is the original form of originalism. It has a similar fixation principle and constraint principle that originalism does. But I'd like to test its application to Justice Scalia in particular a little bit, just because I find it really hard to square his position in McDonald with his position on flag burning. I feel like a argument could be made, and perhaps if we could hear some pushback, that would be great, that Justice Scalia in the flag burning case didn't really care that much about the outcome either way. I'm not sure if flag burning, it's okay to not like flag burning, but whether it's a really big issue of concern for Justice Scalia is another question. So could that be a strategic loss to emphasize the principle of originalism in interpretation that then he can reject in McDonald in favor of substantive due process, instead of following along with the Alan Gurr argument?
Yeah, I agree with that. It's instrumentally valuable for the court and for individual justices to have a certain set of cases that they can point to, or that the rest of us can observe and recognize, are cases in which their sort of policy preferences go in one direction, the originalist evidence goes in the other direction, and they in fact follow the originalist evidence. So yes, I agree with you, that can be very instrumental. How self-conscious they are about this, how, reflective and self-conscious they are, either individually or as a group, is a sort of another question.
Thanks for the question, and I'll take this opportunity to try to respond to you, but also respond to something that Judge Thapar said earlier, that I'm sure Justice Scalia was concerned about what might end up happening if you fully embrace privileges or immunities, because guess what? It was put in the 14th Amendment to protect a broad array of individual rights. Why? Because southern states were keeping newly freed blacks in a state of constructive servitude. With an unbelievable, dizzying array of regulations, and the idea that you could come up with some bullet point list, oh, you can't do that, can't do that, can't do that, impossible. And so I think that's almost certainly what the purpose of the privileges or immunities clause was.
Can I interrupt you? As proof, you can just go read Justice Thomas's concurrence where he lays all this out.
Right, it's a very powerful opinion. But the point I wanted to make was, okay, so Justice Scalia, I get that makes you very nervous, but it seems to me the mirror image is, let's say, Justice Breyer in the case that just went out of my head, the gun-free schools case, Lopez, right? Where Justice Breyer's concern in that case is if we read the enumerated powers, doctrine too narrowly, then the federal government won't have the power to do all the things it needs to do. And as a libertarian, I'm like, I get both of your concerns, guys. But we're not going to be substituting our personal preferences or anxieties for the contrary text of the Constitution, are we? Well, the answer is sometimes yes, and sometimes no.
What about and if you have questions, please raise your hand, but what about Justice Thomas then? Let's switch over to kind of what people consider the preeminent originalist on the court, although, as I think John fairly said, Justice Gorsuch, you can throw into that category as well, but longer serving, Justice Thomas. And whether you look at Lopez, where he wrote separately, and then Gonzalez v. Raich, where Justice Scalia, Justice Thomas again on opposite sides, or you look at the Privileges or Immunities Clause, where Justice Thomas was consistent, is there a similar critique of his originalism not constraining him? Can you point to cases where he you can say he's wrong, that's different. That's not saying originalism's not constraining him, you're just saying he's wrong on his original matter. The tariff case, you can also point to his Hamdi and all those cases from the terrorist era where he's consistent with what he's saying now. So his view hasn't changed. Mm-hmm. And I think one of the beauties of originalism is you can critique people. If I just say, it is so because I think it should be so, well, too bad. What are you going to critique? The way I think? If that's what I want to do as a judge. But if originalism is truly constraining, is it constraining of Clarence Thomas? And can you point to cases where you can say, he's not doing originalism?
So it's a fair point. I'll try to jump in and then
hand
it over to you, Clark. But I don't know how many of you know this, but Judge Thapar has a book on Justice Thomas's jurisprudence. And so I actually, of the three of us, I think he knows it the best. I don't feel as equipped to talk intelligently about all of the different opinions that Justice Thomas has written and whether there are some departures from originalism. I actually don't know the answer to that question. Nothing is coming to mind specifically. I'm sure I would think he's signed on to certain opinions as a silent additional vote with the majority. He hasn't always written separately to lay out an originalist view, I think. But, you could correct me if I'm wrong. I will pick up on something you said and just make a further point. I think it's a fair point. Of all the justices, Justice Thomas and maybe Justice Gorsuch are the ones where I actually feel like if I had them in a room, I would know how to try to persuade them to see a certain part of the doctrine differently, and that's because of their professed commitment to originalism. I know a fair bit about some things in constitutional history, which I've studied intensively, and in some cases I think they have a warped or distorted understanding of the original meaning of the Constitution. And I could actually have those conversations with them precisely because of their commitment to originalism. But I think you make a fair point. A non-originalist justice, I'm not sure what I would say. I wouldn't have any kind of I could make normative arguments like we all can make normative arguments, or maybe arguments from precedent and so on. But it's just a totally different kind of a posture. And I do think that is something, at least, if not constraining, I'll call it constructive about originalism. There's a sort of, you understand what it would take, at least, to make arguments that could, in principle, persuade a justice committed to originalism. And I do think that is, a virtue, actually, of the whole enterprise. insofar as they're willing to be consistent. I'm not sure they always are, but I'll leave that aside.
I think Justice Thomas is probably more constrained by originalism than any other justice at this time. So sometimes, yes. Only with great trepidation do I throw this out there. So I'm not making a strong claim here. But I always found Justice Thomas's view, I would say his consistent view, that students basically lose all of their constitutional rights once they set foot in a public school to be a bit difficult to reconcile with my perception. I don't want to say my understanding, but my perception of the attitude of founding era, not elites necessarily, but people fluent in the political theory that produced the Constitution. They were pretty willing to allow government officials to be sued when they violated people's rights. I'm not sure how sold they would have been on the idea that, well, where'd that happen? Oh, it was in a school? Oh, okay, that's fine.
Yeah, I think he recently signed on to an opinion, to John's point, I can't remember the name, so I'm sorry, where he said, I think these kids have no rights, but I agree that's the precedent, so I'm going to follow it. And he literally wrote a concurrence saying, yeah, no, they don't have rights, but this is the law, and properly applied, the majority gets it right.
Yeah, in the case I was thinking it was Bong Hits for Jesus, which if you haven't heard of it, just,
Yeah.
commit that case to memory because you just get to use that one. It's the actual name of the case. So,
Yeah. And that might be the case,
Okay,
where
yeah.
he did it, yeah.
Yeah.
Thank you for speak with us. I'm wondering if you guys can speak a little bit about the role of prudence in originalism.
I'm sorry?
Prudence.
Prudence, okay.
I remember when Justice Bennett, Derek came to speak with us. She kind of talked about prudence and how she was saying that she wanted to become more prudent and kind of practice prudence in her jurisprudence. I found that to be really interesting, and I'm wondering if you guys can expand on the idea of how prudence interacts with originalism, how it may lead some judges to originalism, or how it might lead judges away from originalism.
I have thoughts. I'll give you two concrete examples, and I haven't had time to think through these, so maybe they're just completely preposterous. But I'm not in court, so it's not going to cost me anything. Not going to cost me anything.
I'm going to quote you. No, okay.
So I was chatting before the event began about the role that originalism is or is not playing in the court's Second Amendment jurisprudence, including the Bruin decision from 2022, where the court struck down a New York law that was highly discretionary in terms of who got a permit to carry guns, and they embraced this very originalist, or ostensibly very originalist framework that essentially they're not going to use tiered scrutiny, but they're going to look for historical analogs when evaluating the constitutionality of a modern law. And it's not at all obvious to me why we would apply the exact same framework, or arguably the exact same framework, to the concerns we have today about, let's say, the use of guns in public places, when at the founding era, guns were muskets. They shot a projectile about 1/3 the velocity of modern rifles, and every building was made either out of logs or rocks or both. That slug wasn't going any further than the wall of that pub. And nowadays, you've got a modern sporting rifle. We call those that's what you guys call an assault rifle. A modern sporting rifle, shoots a projectile at roughly 3 times the velocity of a colonial era musket, and it's going through drywall. Prudence would suggest that maybe that's a basis for making a distinction, it seems to me. And then the other one, I guess, would be, and I don't want to open a whole can of worms here, but what if it turned out to be that legal doctrine looked a particular way because there was an entire segment of the population that didn't get to participate in the political life of the country? We could call them, I don't know, women. And so if we were to go back in time and say, well, that's how they did it back then, and it must be fine to do it back now, it's like, well, wait a minute, they weren't even represented at all, in the public square. So why would we not update that heuristic? Does that make sense that we might at least consider doing so? And that strikes me as another example where we might say that prudence could enter into an analysis, an ostensibly original analysis, and not necessarily throw it completely off the rails.
There's another word I like to tell my clerks about, which is judgment.
Yeah.
There's a component when you're doing all of this, a judge who, I will talk about being an originalist, but there is a time where you get to a point in the case and there's only so much information and so much time you have, and then judgment kicks in. And that is a central component. It gets to prudence a little bit, but it's a little different. And judges exercise judgment, hopefully 100% of the time, no matter what they're doing. And that does have some overarching feel to it. We don't have time, but I had a case called Felmy. It's a Fourth Amendment case, and it talks about reasonableness and all these things. It's about a dog search. And we literally went through the Jones analysis, or I did. I went through the Jones, like we had a per curiam to dispose of the case. And then I went through the entire Jones analysis, and then I had a whole section on basically judgment. Like I read Orrin Kerr's law review. Yes, I'm one of those sick people that reads law reviews at night.
This is good to know.
Yeah, and
You feel seen?
Yeah,
that's right. And you know, I went through kind of what he was thinking, and then the judgment section, like, is this really where we're going? And so I asked a bunch of questions, and the point being is, you know, sometimes in lower courts especially, we're trying to faithfully apply, as John referred to earlier, the Supreme Court doctrine. And we're doing our best. But sometimes we need some help. And we're like, look, you left all these questions unanswered, and you know what? History, tradition, all these things, they don't give us the answers. So in those cases, until the Supreme Court tells us we got to apply judgment, but it doesn't hurt to write a concurrence and say, look at all these problems with your doctrine, now tell us what to do if you want us to keep doing this. Can we take one more if we have any? Yes. Yes.
So, kind of speaking to that prudence and law review, I know Larry Solem put out a distinction between constitutional interpretation and constitutional construction. Seems like that might be one of the originalist terms for trying to get prudence back in the game, trying to get some other things involved other than. Is that the right way to think about that, or how is that not loosening some of these restricting forces that are supposed to be part of originalism?
That's a great question. You guys
It is a great question, and it's a wonderful distinction that he drew, and many originalists draw upon it. Keith Whittington is another person who's written about it. Yeah. So I think the basic idea is that the authoritative legal materials run out, as Judge Thapar just said, often, even with the best faith effort to try to understand them and see how they might apply. What happens then? Well, the argument is that then one is in the construction zone. There's a sort of certain amount of additional interpretation and application that has to take place. The question then might be what constrains the judge in the construction zone. But certainly prudence and a variety of traditional modes of judging would come into play. So I was actually thinking when Judge Thapar was just talking a moment ago, even though he's a lower federal court judge, an eminent one, he's vested with the judicial power of the United States. And that's a substantive power. So I would suggest humbly that in those moments when he's bound by precedent, as is every other lower federal court judge, and they're trying, as he said, to really understand both what the law compels, but also what the court has said the law compels. But there is, I think, often room for judgment, just as he said, and it comes straight from the Constitution. I mean, I think you actually are vested with that authority. And in general, I think judges shouldn't be afraid to use that power, because that's what it was actually put there for. I mean, I think that's what the founders, frankly, would have expected and wanted.
I'll give you two examples. One of them whimsical, maybe both, just to come full circle. So one's concrete from a concrete case. Some of you may have heard of this case. It's KYLLO. I think it's Kylo, which is a Fourth Amendment case about the use of thermal imaging. The police were sort of driving through a neighborhood looking for heat blooms inside of houses because they were afraid people might be growing tomatoes. No, I'm sorry, it wasn't tomatoes. And if you think you're going to get, the right answer in that case through strict interpretation of the term unreasonable, I think you're dreaming. I think you're at least doing construction. You may be doing some combination of prudence and judgment, and fair enough, right? And I think that's inevitable, and I think we shouldn't, sort of shy away from it. And the second example is going to be flippant, so I'll just end there.
Yeah, the one area I'll say that's really interesting right now, worth looking at, I wrote a case called United States versus Williams. It's about whether felons in possession can have a Second Amendment rights, and this is mostly originalist writing if you look across the country, and we're split pretty evenly. Some say, no, Congress can ban them all, and that's kind of a Thayerian, I don't want to say they're doing Thayer, because that would be unfair to my friends. They're doing restraint, and you could argue. And then there's people like me that say, no, you can't ban non-dangerous people, and here's all the historical evidence. Now, I'm not saying I'm right. I'm saying I'm on one half of the divide, and I think I'm right. But there's another half that says, no, Congress can ban everyone. And so it's a really interesting discussion. If you go read, I bet there's 10 to 20 opinions now. Mm-hmm. And I'm telling you, if you went Trump appointees, I bet they're split 50-50. If you just take Trump appointees, I bet they're half on each side.
Justice Barrett on the Seventh Circuit was on your side. You know.
Right,
Yeah.
And so it's an interesting kind of dialogue that we're having, but we're trying to do this history and tradition. We're using a little bit of judgment. We're looking back at the laws, and as Clark pointed out, laws aren't perfect. Like the historical, record isn't perfect. I wish it was. It'd make our life a lot easier. But I can tell you, I read every one of those. I went through all of them, and I thought they all had exceptions, and I pointed out. Now, you can go critique it, because I lay it all out. But at some point, I got to make a call, and I made the call. Yeah. And I'm telling you, I'm splitting from some of my closest friends on the bench. So.
And there's a strong intuition there, I'll at least describe it as I understand it, which is we don't think that convicted felons lose their rights to free exercise of religion, or could be stripped of those. We don't think that they could be stripped of their other First Amendment
Or
rights.
have kids.
I mean, there's a certain strong understanding of the limits of government power with respect to other rights. And so what's the distinction here? Now, maybe there's an argument, maybe there are arguments to be made, but that should at least, I think, be the starting point. There should be kind of the default, the presumption should be, we at least should expect an answer to why not consistency.
Yeah, the only thing I would say is, and I'm on that side obviously, is just go read some of the other opinions, because they're by very thoughtful people, and they're very well done.
Yeah,
that's all I'm going to say.
Yeah.
And so...
Wrong but thoughtful. I said it.
Yeah.
I said it.
Supreme Court will be the judge of that.
Yeah,
With that, we'll finish. Thank you all very much.
Thank you all for coming. I just wanted to flag the next debate will be Monday, March 16th. It was the debate that got snowed out in January, so please come for our speakers get rescheduled. It's Judge Rao moderating whether Humphrey's executor was rightly decided with Mark Chamberlain and Nancy and Harold Pratt. So please come.
Thank you.
That's time so much. Thanks, Dennis. Thank you. It's great.
It's so nice.
Thank you so much. Yeah.
Thank you.
I know.
Loved your example. Thank you.